Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in the series of company law, let us learn who are these promoters, what is their fiduciary relationship with the company and what are his powers. Who is this promoter? The term promoter is not defined in law, but all the business operations necessary to bring a company into existence are called promotions, and the promoter is the first person who controls or influences a company's affairs. Thus, persons who initiate the promotion of a company are known as promoters. The promoter of the company is a person who employs himself in the preliminary work necessary for the flotation of the company. In the Act 2013 under Section 2 Clause 69, promoter is defined as he is a person who has been named as such in the prospectus or is defined by the company in the annual return to it in Section 92, or the promoter is the person who controls over the efforts of the company directly or indirectly, whether as a shareholder, director, or in any other person. And the promoter is the one who advises, directs, and instructs the board of directors of the company in a accustomed act. In all these things, provided nothing in the subclass C shall apply to a person who is acting merely in a professional capacity. From the definition, we have already understood that promoter is the one who helps in promoting the company. He is not an agent or a trustee to the company, but he acts in flotation of the company, because the company before incorporation is a non-entity. He is kind of quasi-trustee because he occupies the position of a quasi-trustee because his dealings must be open and fair. So let us learn what is this fiduciary relationship with the company as a promoter. What is his liability? This can be easily understood with the help of a case law. Erlanger versus New Sombrero Phosphate Company. Here, Erlanger, he was the promoter of New Sombrero Phosphate Company. Before incorporation, the company Erlanger purchased an island containing phosphate mines for £55,000. Thereafter, he made efforts for the incorporation of this company. He named 5 directors, out of whom 2 were abroad and 3 were fully under his influence and control. After the incorporation, the director purchased the complete mine from the Erlanger, who is a promoter, for £110,000 and paid the amount to him. Thereafter, several persons purchased the shares from that company. In the first meeting of shareholders also, the sale of mine was approved. However, the company faced a lot of losses and it was liquidated. The liquidator found that this Erlanger, who is a promoter, he purchased the island for £55,000 only, but he sold it to the company for £110,000. So he sued Erlanger for making a secret profit. The promoter said that the directors knew the fact that shareholders also approved in the first meeting. But what the judgment came is, Lord Keynes, he rejected the contention of Erlanger and he gave the judgment in favor of the liquidator and said the promoter to return the amount of excess profit he has gained from the purchase of that land, that is 55,000, to that company. After this case law, Lord Keynes, who is the judge, he gave a statement that in equity, the promoters of a company stand in a fiduciary relation to it, and those persons whom they induce to become shareholders in it cannot in equity bind the company by any contract with themselves as the promoters without fully disclosing to the company all material facts which the company ought to know. So there should not be any kind of secret relationship. All that facts should be disclosed and nothing should be in a secret manner. So let us learn what are his fiduciary, what is his liability towards the company. Not to make any secret profit, we have understood from the case law. The promoter must not make any, either directly or indirectly, any profit at the expense of the company which is being promoted. If any secret profit is made in violation of this rule, the company may, on discovering it, compel him to account for it and surrender such profit. The second liability is he has to give the benefit of negotiations to the company. The promoter, once he begins to act in the promotion of the company, must give to the company the benefit of any negotiations or contracts which in which he enters in respect of the company. And he has to make full disclosure of interest or profit as per section 26 clause 1 subclause E of the Companies Act 2013. The promoter requires earnings to be disclosed in the prospectus itself if it is not the profit by the promoter and the law forbids, but the non-disclosure of it and the non-disclosure of the interest in the transaction also. If full disclosure is made, then the profit is permissible. And he should not make any unfair of the position. The promoter must not make any unfair or reasonable use of his position and must take care to avoid anything which has appearance of undue influence or fraud. Those are the duties and liabilities of the promoters. Let us look into the powers of the promoters. A promoter has no right to demand remuneration from the company for the services rendered by him, but he can demand a right if there is a contract to that effect. And the next is, if he incurs any legal expenditure, he has the power to get it back with the approval of the shareholders. Legally, there is no provision to give commissions, shares or remuneration to the promoter, but practically the promoter is paid by means of commission on the shares sold or a lump sum by the company or any remuneration. He may be absorbed or appointed as a director or a managing director if there is an approval from all the shareholders. As such, we have come to the end of the session. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe. Thank you.